We are awash in creator energy at all times. So long as we are breathing, so long as we are unlimited in what we choose to create. It is most often our limited thinking that keeps us from creating what we think about or wish for. So often we look outside ourselves to deny our power to manifest, when it is generally our own inner doubt, denial, impatience, or fear that keeps us from realizing, shaping, or manifesting. There are myriads of responsibilities, interruptions, and distractions weighing on us constantly. This is why there is importance in taking time away, a time out, precious alone time, to allow creative space from within. Along with all the material, monetary, and intangible things stolen from us by our captors, the pirates, imagination has all but been stolen from us as well. When we can no longer dream awake, no longer have motivation to create our thoughts or awake dreams into reality, we are dead to the vitality of potentialities that spring from Source. This living life energy must attention, not to be overridden nor denied by our busy lives that can become rutted with pattern, predictability, and outside forces of every ilk and intention. This creation we have been created for is ours to have and to hold, to dream it into a reality that is of our creation, to bring all the manifestations we can imagine into the material, if only for the benefit of creation itself. Taking time out of the equation allows us to be patient with the shaping of our inherent creative nature. It is this creative nature that is our lifeblood and of life itself, the juice of life. Let it be so, and so it is.
Hello, I have some information transfer from the Oregon Statewide Jural Assembly to the people in governance that are persons that are opposing a constitutional Republican form of government by supporting Article 7 amended in our Constitution on Oregon. This is illegal and illegitimate. It's de facto. It's color of law. There is no proof, there is no evidence that it is legitimate. Therefore, it is fraud. So, I'd like to read you a little bit about 18 USC 241 and 242. Let's start with 242. Deprivation of rights under color of law. That's what we have. You people are pretending that Article 7 amended is legitimate. And that's a lie. That's color of law. You're guilty. All of you. 242 of Title 18 makes it a crime for a person acting under color of any law to willfully deprive a person of a right or privilege protected by the Constitution or the laws of the United States. That's pretty clear. For the purpose of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official lawful authority. If the acts are done while the official is purporting to or pretending to act in the performance of his or her official duties. You have been warned. You have seen the grand jury make decisions on this, and you've been tried. Now we're going to bring it to the county commissioners. Not the way we wanted it. We wanted you to do the right thing. be jure, but you're choosing not to. Then we have more under Title 242. Offense is punishable by a range of imprisonment up to a life term. Boy, you'd really have to be bad to do that, wouldn't you? Kate Brown bad. Tina Kotek bad. Then we get to 18 U.S.C. 241. Makes it unlawful for two or more persons to agree to injure, threaten, or intimidate a person in the United States in the free exercise or employment of any right or privilege secured by the Constitution or laws of the United States, or because his or her having exercised such a right. Unlike conspiracy statutes, 241 does not require as an element the commission of an overt act. Offense is always a felony, even if the underlying conduct would not be in its own. Establishing a felony violation of another criminal right statute is punishable by up to 10 years imprisonment. Don't want to do that one either. What we have is a judiciary and an Oregon state bar that are illegal and illegitimate, and an attorney caused Article 7 amended to become part of our Constitution. How all that happened and everything, I don't know. I've read lots of stuff. It happened. Frank Benson got it done. Then he was dead a year later in California. Funny thing. In any case, we didn't do it. It was done to us. And you know it. And you don't do anything about it. And we have people sitting on the bench pretending to be judges, and we know it. We have proved it. They have acquiesced to it. A wrongdoing judge is an anathema and an enemy of man. To a judge who exceeds his office or his jurisdiction, no obedience is due. Do you get it? We're here. Article 1, Section 1. You're there without a proper oath. All of you, all the way down. The entire state of Oregon governance is illegal or illegitimate. And it's been operating that way for the better part of 115 years. Now, when we started the Oregon Statewide Jural Assembly and didn't have a name, it was just 4 or 5 of us, or 10 or 15, and varying, and people came and people went. And one of them was a guy named Roger Tabb. Rest in peace, Roger. Those books behind me, the printed, reprinted first edition of Black's Law, 1891. I got that from Roger. I also got this book from Roger. Yeah, you can see that. It's put out by the State Justice Institute, the Anti-Government Guidebook. The managing editor, Chuck Erickson, active and executive director, the National Center for State Courts. His 800 number is 800-616-6164. He doesn't respond to me. Then there's contributors and primary researchers. And Mr. Chris Wesser, JD. Well, at least he's not an Esquire. And Mr. Dove Zago, another JD. Both of them from William and Mary. The National Center for State Courts, 300 Newport Avenue, Williamsburg, Virginia, 757-253-2000. Yep. Quite an undertaking these folks have done here. Lots of good work. I want to read just a little bit at the very start of it. Decency and security and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen. In a government of laws, existence of the government will be imperiled if it fails to obey the law scrupulously. Our government is the potent, the omnipresent teacher. For good or ill, it teaches the whole people by example. And the example of our sheriffs is, you cannot abide by your own law. ORS 206. Doesn't seem right. Doesn't seem like the judiciary would jump in and make Article 7 amended illegitimately and illegally and get it into the Constitution, and 115 years later there is no proof to be found anywhere to support that. It's there de facto. And will you remove it? No. Have we tried? Yes. Has Kate Brown, Ron Wyden, Suzanne Bonamici, and Jeff Merkley all been found with the true bill from a grand jury and the true bill to an Article 7 original jurisdiction, Article 3, one Supreme Court claiming original jurisdiction, and Amendment 7, Civilian Common Law Court of Record having implemented Ex parte Milligan? We are the only legitimate Article 3, one Supreme Court in original jurisdiction, common law court of record that fulfills the requirements of Amendment 7. And Article 7 in Oregon's Constitution eliminates Amendment 7, which is unconstitutional, but there it is. So what did it say? No obedience is due, and I give them none. I have a hard time even talking respectfully to you folks that we have worked so hard and so long on. We don't stint our effort nor expense. And we have done it step by step, grand jury, true bill, trial, verdict, posting all of the bulletin boards for 60 days in 9 counties, serving paper to all of the sheriffs or their appointed representatives twice. And now we're taking you before a county commission. Yamhill County and Sam Elliott. Coming up on the 18th, McMinnville, room 32 in the basement of the courthouse. And I yield.
Hi, I'm Eric Dover with the Oregon Statewide Jural Assembly, and I have some messages for the Oregon sheriffs. Where are sheriffs? Our Article 3, Amendment 7 Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system, rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are sheriffs? It is significant that they take a proper oath to the Constitution, circa 1859, with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator, that is, with God included. Such a dejuration, an oath, is needed for there to be remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make a difference, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so.
This is a notice in demand from the Oregon Statewide Jural Assembly. Notice to principal is notice to the agent. Notice to the agent is notice to the principal. And the cause number is 0822-2025, Notice Defining Terms. Jura Summa Imperii, page 701, volume 1, Bouvier's Law Dictionary, 6th edition, 1856. Sovereign, page 589, volume 2, Bouvier's Law Dictionary, 6th edition, 1856. In the United States, the sovereignty resides in the body of the people. We, you, and I, have the rights of sovereignty or supreme dominion. Most of us are stuck in the de facto. We have been educated with MK Ultra since 1947, when the Attorneys Treaty, the United Nations, and other infringements were started, thus moving the seat of power to the United States of Washington, District of Columbia, Inc., in some form of de facto since 1861. A double down in 1913 and again in 1933 with Project Paperclip, the Nazis, jihadists, socialists, communists, et al. Are not Article 4, Section 4, not the McCarran-Walters Act of 1952 and 65, and not the constitutional Republican form of government. Did you get 5 years of education in the Constitution starting no later than the 8th grade? You and we all know that ORS has been long ignored. What we do have is not good, while the current form of the Salem oligarchy continues to run its course. It has failed and we are no longer deceived. There are over 200 United Nations members, most of whom are monarchs or presidents of their countries for life. We have the 1871 de facto version going on here in the United States right now. Currently, we have the DJT version of martial law, Libre Code FEMA. It is just changing the de facto again. They do not want to go anywhere near Jural, except us on Oregon. Jural means by right, by law, by all of our unalienable rights guaranteed by our constitutions circa 1859. This is from Bouvier's Law Dictionary, page 701, volume 1, 6th edition, 1856. Black's Law Dictionary changed the definition of jure to align with the de facto. Facto means in fact, in contradiction to the lawfulness of the thing, end quote. From Bouvier's Law Dictionary, page 517, volume 1, 6th edition, 1856. Here, as well, Black's changed the definition to align with the de facto. De facto, in Black's dictionary, is illegal and illegitimate. That's a quote. Page 416, volume 1, 6th edition. Jure in Black's, quote, is lawful and constitutional, end quote. The fact that neither definition exists in Bouvier's Law Dictionary, 6th edition, 1856, indicates that the de facto government didn't come into existence until circa 1871. Our de facto on Oregon is a fact of fraud, as evident by Article 7 amended in our Oregon Constitution, circa 1910. The entire Salem oligarchy continued with Kate Brown acting as governor, who was responsible for requesting the FBI and was in direct control of the Oregon State Police. To discourage discovery of their dirty deals regarding Uranium One and the BLM land grab water rights issue, they murdered Lavoie, then buried the tragic loss of a man standing with fellow ranchers on his way to negotiate a peaceful resolution. The Salem legislature exonerated the killers and shooters in the Oregon State Police. Thereafter, they shut us out of our legislature's proceedings. What ensued on January 21, 2021, was one of a series of due process violations. Tina Kotek was Speaker of the House at the time. She has no honor and may not hold a position of trust. The Judiciary on Oregon, the Supreme Court, and their counsel acquiesced and defaulted twice. Article 7 amended is fraud upon the people. Look up Wally Carson from decades past. The Constitution Party. Milt Mitchick, an Oregonian who spent much time researching and traveling Oregon to create the important revealing booklet Vultures, republished at our website, www.orsja.org. This is where you can also find our Oregon Judiciary Journal newspapers, Bouvier's Dictionary 6th edition, our instruments, documents that are signed, sealed, stamped, witnessed with proof of service, and published. You can also find us on 3CTV Weekly, YouTube, and Brighteon. Read, learn, respond. Thank you for listening.
This is Bill. I'm with the Statewide Jural Assembly, and I'm reading some statements for the sheriffs. Where are our sheriffs? Our Article 3, Amendment 7 Civilian Court of Record has made numerous visits and relentless communications to our county sheriffs in Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their homes and all they possess. It should be our county sheriffs who protect and defend the people from the corrupt court system rather than ticketing them and supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us. The people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are our sheriffs? It is significant that they take a proper oath to the Constitution circa 1859 with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator, that is, with God included. Such dejuration, an oath, is needed for there to be a remedy in our system of governance. Let's get the ball rolling. It just takes one of you to make a difference, to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up.
And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.